Realize.
All right, good morning. It is April 2nd and the Senate Judiciary. We have Eric Fitzpatrick from Lead Council to do a walkthrough on H606.
Morning. Eric Fitzpatrick with the Office of Legislative Counsel here to talk with the committee about House Bill number 606, which is an act relating to firearms procedures. Held by sort of the general nature of the title, that it's several different discrete procedures related to firearms. It's not all one thing. 4 different sections in the bill, 2 of them are related. So there's basically 3 different firearms related issues going on in the bill. So I'll walk the committee through each one, give you a description of what's proposed in each of the sections. And that will should give you a good introductory walkthrough.
Hold on one second. Are you looking at draft 1.2? Is that what we're walking through right now?
Nope, we're walking through H606 as passed the House.
Oh, okay. Okay. I think we got a proposed amendment in front of us. I think Emery's gonna grab us as passed by the House.
Okay.
Yes. What's the while he's working on that, since we already got started, what is the first section?
First section is the most straightforward one of the bill, so I probably can explain it a little bit before we even look at the language. So first section has to do with it, sort of stepping back for a second. I think everyone remembers on the Judiciary Committee that it has to do with property crimes. And in Vermont, remember that the distinction between felonies and misdemeanors with property crimes is monetary. So it all depends whether the amount of property is stolen or the amount of property embezzled or amount of property that is subject to the crime is either $900 or more or less than, or sorry, it's $900 or less or worth more than $900. If the amount of property is $900 or less, it's a misdemeanor. Right? If it's more than $900, it's a felony. So a person steals property that's worth more than $900, that's probably a felony. But less than 900, a misdemeanor. So with that knowledge in mind, the proposal that in section 1 has to do with the grand larceny statute. As I said, whether it's felony or misdemeanor depends, and this is a phrase from existing law, depends on whether the money or other property stolen exceeds $900 in value. So the proposal is that if it's a firearm that's stolen, then it's a felony, regardless of the value of the firearm. And so you wouldn't have that $900 demarcation between felony and misdemeanor with respect to a firearm. The property is firearm, then it's going to be a felony, regardless of how much it's worth. So it's pretty straightforward, actually, that first section.
I do have one quick question there.
Yeah.
When you say a firearm, does muzzle loaders come into play here?
No, actually, because you have to recall that the firearm is defined in the law 2 different ways. Sometimes it includes antiques like a muzzleloader, and sometimes it doesn't. For purposes of this provision, it uses the federal firearms definition, which doesn't include antiques and muzzleloaders. So no.
Well, a lot of them are not antiques now.
I know, right?
No,
Right.
rifles, but there's still a fellow can possess one and use it. So
Yeah, I think the underlying idea behind the proposal is that, it's generally speaking that the firearm will only be done for some violent criminal purpose, but that probably would be the case if someone steals muzzleloader. So that's why they don't not see that for purposes of that change. So I can pause for a moment so you can see the list that everyone has the bill now, right? So if you look at page 1, lines 14 through 60, that is what I just described in language. So you see, generally speaking, line 14, whether it's felony or misdemeanor depends on the $900 value, or it's a 10-year felony if the property stolen is a firearm of any value. So it doesn't matter about the $900. Although, as you just mentioned, Senator Norris, that wouldn't sweep in muzzle loaders, antiques, that sort of thing. So that's section 1. Move on. All right, section 2. This deals with actually sections 2 and 3 both deal with a concept known as prohibited persons, or sometimes referred to as prohibitors. That's categories of people that are prohibited from possessing firearms. All 50 states have prohibitor statutes. Vermont has a couple of prohibitor statutes. The federal government, Congress has passed prohibitor statutes, but not an unusual concept at all. And in fact, constitutionally, that's been long held that this general approach is constitutional. I'm going to read you just a phrase from District of Columbia versus Heller decision, 2008, which has also been repeated since then in the Bruin decision, which we talked about a lot in this committee about how it is you analyze firearm statutes to determine whether they're constitutional or not. So the phrase from the BC Heller case, which has been repeated by lower courts all the time, as well as subsequent Supreme Court decisions. And so Heller recognized this Second Amendment right to possess a firearm for self-defense, right? Personal right that had been articulated in Heller for the first time. And said, recognizing the right to keep bear arms for self-defense, quote, does not cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. So it does not cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. So recognizing this idea that that's two categories, two prohibitors right there that were recognized in the Heller case. People who've been convicted of certain violent crimes and people who have mental illness or mental health. So those two categories are what are being dealt with in Section 2. Section 2, we'll take a look at that for background. So look at Section 2 now. That's going to be the first category. This is a statute. You look at it, starts at the very bottom of page 1. This is Vermont's, for lack of a better term, felons in possession statute. They're often called that, but it really has to do with Vermont has used the term convicted of a violent crime. That was passed back in 2015, and that's when Vermont put this statute into place. It says if you've been convicted of a certain type of violent crime, you can't possess a firearm. Prohibition is unlawful. If you turn over onto top of page 2, you'll see that the language that's existing law, top of page 2, lines 1 and 2, cannot possess a firearm if the person has been convicted of violent crime. Violent crime is defined later in the statute. And what's the penalty? And that's all that this section deals with. It doesn't change this provision of law, other than with respect to what the penalty is. Current penalty, you see there, page 2, lines 4 and 5, it's a 2-year misdemeanor. 2 years in prison, $1,000 maximum fine. Misdemeanor, because 2 years is, remember the threshold between misdemeanor and felony in Vermont. So what's the proposal? This has to do with second or subsequent offenses. So right now, it doesn't matter whether it's your second, third, fourth, fifth conviction, whatever. It's always the same penalty, 2-year misdemeanor. The proposal is if you get convicted of this for a second or subsequent time, in other words, you were already convicted once of possessing a firearm after you've been convicted of one of these violent crimes, so you weren't supposed to have it. You get convicted of that again, then it becomes a 3-year felony. That is on line 6 and 7, page 2. And that's the only change to that category of prohibitors. Prohibitors being prohibited on the basis of their criminal.
Then the rest of check for definitions.
Exactly. It's referred to included in context so that the definition, because it really depends on the definition of violent crimes, what firearms are included. And Senator Norris has given it this. If you look at page 2, line 11, Senator Norris, that's the definition of firearm that is based on federal law. That you see, line 16 does not include an antique. And again, not always an antique these days, but the way it's defined is to include matchlock, flintlock, similar types of ignition system over on top of page 3. Any of these other muzzle loaders are down on line 8, black powder, that sort of thing. So all those sorts of firearms you're talking about are not included. A person could still possess them, or in the case of the first section we looked at, it's not a felony to steal one regardless of value. All right, so that's in section 2. Section 3, which we'll move, unless I could pause for a second. Section 3 deals with a different category of prohibited persons. The other one that I mentioned, from that little passage I quoted from the DC versus Heller opinion, referred to felons, persons with criminal convictions, which we just looked at. Section 3 is that second category, people who are prohibited from possessing firearms because of their mental health issues. And that also exists in all 50 states and under federal law. I'm going to pass out a handy Bureau of Alcohol, Tobacco, and Firearms and Explosives chief that defined the federal prohibition. And this is helpful to understand because the way the proposed language is structured and the way Vermont law interacts with federal law on this is going to be necessary to understand if you're going to understand how this proposal works. So, if you look at the federal law first, this is, and there's an extra there, which I think actually is around here. So, process running. Thanks. All right, so I could say, first of all, that the federal law was written in 1968, and it uses language that I think everyone would agree is offensive and archaic, and it's not used anymore. But I need to repeat it because that's what the law says in the federal language. I won't be phrasing it that way otherwise, but I just want to put that out there so that the media and everyone understands why we use terminology. So the federal law says that under 18 U.S.C. 922 G4, any person who has been, quote, adjudicated as a mental defective or committed to a mental institution is prohibited from possessing firearms under federal law. All right, so that's the term that the federal statute uses. The federal regulations then define, well, what do those terms really mean? You look at the first one. This is the within the box on the handout that I passed out. Adjudicated as a mental defective. A court, board, commission, or other lawful authority has made a determination that the person, as a result of marked subnormal intelligence, mental illness, incompetency, condition, or disease, is either danger to himself or others, lacks the mental capacity to contract or manage his own affairs, is found insane by a court in a criminal case, or found incompetent or not guilty by reason of insanity by the Code of Military Justice. So this is actually related to the bill that the committee just looked at, the forensic facility bill. The same concepts are actually crucial to understanding what's going on here. Because remember, when we talked about the forensic facility bill, the committee was talking a lot about not guilty by reason of insanity and incompetence to stand trial, lack of competency to stand trial. And the procedure, if you remember, is that if the court finds either one of those things, NGRI or lack of competence, then have that hearing to determine whether or not you're a danger to self or others. If you are found a danger to self or others, then you get committed to the Department of Mental Health. That happens through the criminal process forensically. It can also happen in the civil process in the family division. An interested person could bring a case in the family division if they think you're a danger to yourself or others. As a result of a mental illness, you can get committed through the civil process as well as through the criminal. That's important to understand because remember, in Vermont, that requires two things to be committed: mental illness and danger to self or others. This federal statute for who's prohibited from possessing a firearm is broader than that. See, we just looked at it. It's not just mental illness, subnormal intelligence, incompetence, condition, or disease. And it's not just dangerousness. That's only one of the reasons that can get you prohibited under federal law. Dangerous, lacks mental capacity to contract or manage your own affairs. That could be, for example, someone who's subject to a guardianship, involuntary guardianship. Not necessarily dangerous at all, but it could be a family member who has a great guardianship condition who can't manage your own affairs. So it's broader than who have to be who can be committed under federal law. Under state law. Additionally, one thing to remember about this federal prohibition is that it's permanent, right? If one of these things has happened to you, you've been adjudicated by a court as either danger to yourself or others, you don't have capacity to contract, etc., then you're permanently barred from possessing firearms under federal law. And there's an exception there that you sort of look down 3/4 of the way down the page under affirmative defenses. There's an exception if you are able to file a petition in court and get what's known as relief from disabilities. And that means you can demonstrate to the court that you no longer should be prohibited from possessing a firearm because you have mental health status. Recovered, maybe you've got your treatment, maybe you're not dangerous anymore, whatever it might be, you have an opportunity. And we have that in state law as well. It was also passed in 2015 at the same time that this prohibition that we were just talking about, the criminal history law was passed. So, that's federal law. State law right now, this category based on mental health is not a prohibited category. Now, you're still prohibited under federal law if you fell into that group that I just described. Not that you can possess a firearm lawfully, but you couldn't be prosecuted by a Vermont State's attorney in a Vermont state because it's not a Vermont violation.
To clarify, so it would be any court, including state or federal, that makes a finding that somebody is a danger to themselves or others, that would prohibit them on a federal level.
Exactly.
So,
Exactly.
okay. So that's even without this bill.
Correct.
That's the current law.
Yep, that's current law. And another thing, part of current law in Vermont that was passed in when it passed the little section. So if you look on page 606, sorry, as it passed the House, and you look at page 7, line 46, Vermont does have this relief from disability process under current law 2015. So in other words, if you had, like Senator Hashim, as you were just mentioning, if you were committed under the current Vermont, committed for either because you're knocked up by reason of insanity, perhaps, or maybe it happened at the family division, however it happened, if you're committed to the Department of Mental Health custody, you would be prohibited under federal law permanently from possessing firearms. But there is this opportunity under Vermont law, also passed in 2015, that you can, within the family division, file for a relief from firearm disability. Show that you shouldn't be subject to that anymore. Your firearms rights should be restored. So that option is there. Actually, as I said, passed 2015 when Vermont first passed its law prohibiting possession by felons and other people convicted of violent crimes. To provide activities necessary for the time, because in order to qualify for some grants, there was a federal firearms law that required the states to adopt that if they wanted to qualify for those grants. So Vermont does require that even though people are not prohibited, this category, mental illness category, doesn't exist in Vermont. Vermont does have these statutes requiring that that the court report names to NICS, to the National Instant Criminal Background Check. So if you have been committed either forensically through the criminal system, not guilty by reason of insanity, or the family division, danger to self or others, then the court has to report those names to NICS. So that even though it's not a prohibited category in Vermont, still the names have to be sent to NICS so that they can be included on the federal database of people who can't possess firearms.
So then what this really creates, it doesn't create necessarily a new category of people who could be prohibited, but rather it creates a state enforcement mechanism for prohibited persons.
Yes, I think that's exactly right. It doesn't create a new category in terms of people who aren't already prohibited. They are under federal law. It does create a new category for purposes of state law. So yes, it would allow a state's attorney in Vermont to bring a charge in the state court that someone was prohibited by Vermont law for possessing a firearm. Charge.
If I remember right, that 2015 bill had a section that did something similar to your federal law to make it easier for state authorities to prosecute and not have to wait for ATF or.
Yes, the whole section that we just looked at, section 2 about violent crimes, that was all. Those folks were already prohibited under federal law, but that was exactly the idea, to allow that prosecution to be brought to state court by Vermont state's attorney.
So
two questions. I'm sorry, but I'm a little late. I have to do my house committee. This bill essentially kind of aligns state law with federal law on this issue.
Yes. Yes, although it does in the sense that these folks who are prohibited from possessing in this bill are already prohibited under federal law. The only qualification I would add to that is where it gets a little into the weeds. This is only a subset. Remember, as I just mentioned earlier, when I packed out the federal prohibition is much broader
Okay.
than what is in H606. And it's also much broader than what you already have in law. Remember I said under Vermont law already, names have to be reported? That's only, those are only the names of people who have been found danger to themselves or others and committed to the Department of Mental Health, either through the criminal system or through the family division. But as we just looked at in this sheet from the feds, that's only a small portion of the people that are prohibited under federal law. That was intentional.
Okay. Well, and then that sort of brings me to my next question. So we have this ability for people to regain their ability to possess a firearm.
Yes.
That doesn't exist in the federal law. We have a narrower subset. So how does that work with federal law? If someone is prohibited under federal law from having a firearm, how can we, the state, say, actually, that's fine, you can?
That's the federal law specifically says if you go through an approved state rehabilitation process, you're not prohibited by the federal law either. It's feds do have a preparable provision. They also have this.
Oh, okay.
Yeah. It's it was I don't remember if that was passed in 2015 either or it was federal provision predated. But in any event, the Fed law does say that, in fact, even on the sheet of it, not just the federal or an approved state process. Yeah, see, so this is 3/4 of the way down under the affirmative defenses. You're not prohibited if you receive relief from the federal provision, that's the first one, or a proper federal or state authority under a relief from disability program that meets the requirements of the next improvement act. That was the one that the federal law that said you have to have one of these if you're going to qualify for this federal grant money to improve your reporting system.
Okay.
So if you get your firearm restored under state provision, which Vermont has, then you also would be prohibited.
Okay. But that doesn't answer the sort of larger question of our prohibited list being so much narrower than the
Right.
federal list. So under the way we're putting it forward, under state law, you'd be okay to have, some people might be okay to have a firearm, but they would be breaking federal law.
Correct. That's exactly right.
Yeah, section 4822, that's what encompasses ONHs and orders of hospital. They both of those are.
Through the criminal process.
Yeah.
Yeah, exactly. That's we were looking at quite a bit in the forensic facility bill. Yeah. So coming through that process, then whether or not they're again a little bit more in the weeds, but this is also an even narrower subsection of who is going to be covered by Vermont law, because unless it's a violent crime, which we just looked at in section 2, there's a list of violent crimes. If it's not a violent crime, then you're only prohibited. This is line 17, page 6. Then the prohibition only lasts as long as the commitment order lasts. So you haven't been, you're not convicted of a violent crime, but that's not the subject of the offense in the first place of your commitment to the Department of Mental Health. Because remember, you could be conceivably not guilty by reason of insanity or incompetent to stand trial. It's not necessarily a violent crime. It could be any offense, and the court can still find it for dangerous to self or others and commit you. So it might not be one of those violent crimes. And if that's the case, once you come out, which would presumably only happen when you're, I think as you heard from the Department of Mental Health, great detail earlier this session, once you're not in need of that sort of treatment, either because you're not dangerous, you don't have a mental health condition anymore, you're not necessarily going to be maintaining the DMH custody. If that's the case, then your firearms prohibition goes away as well. Only lasts as long as you're committed. So
Eric, during the discussion about the mental health issues, so
Yeah.
before, did the health pick up any discussion on PTS or how that may or may not affect someone's ability to possess a firearm? Or
not specifically. No. I think the idea was that that kind of mental health condition that might impact somebody's ability to possess a firearm, or depends on the underlying procedure, right? You could be found incompetent to stand trial because of PTSD. That's certainly possible. And if that were the case, and if that's what got you committed to the Department of Mental Health, then you qualify for this just like any other mental condition would necessarily. So I think that it is, just over on page 7 now, also, this is the same concept that I discussed in section 2. This is the idea that subsequent offenses for violation by a prohibited person. Currently, it's a 2-year misdemeanor. So it's proposing, you see lines 10 and 11, page 7. Same thing, if it's a second or subsequent offense, it becomes a felony for this other group of prohibited persons as well. That's pretty much section 3. If I can pause there for a second, or we'll go on to section 4. All right, section 4 is another case. Senator Bahovsky, you mentioned this concept earlier, which is making Vermont law parallel to federal law. This is also happening in section 4 with respect to machine guns. So machine guns right now under current law is generally prohibited under federal law. Not a specific machine gun prohibition in Vermont law currently. So the proposal is to add one, but it's to parallel federal law on how possession of machine guns is prohibited. So if you look at page 8, the new language is subdivision 2, which is line 6 through 16. So line 6 through 12, that's just pretty much verbatim the federal definition of machine gun. Any weapon that shoots or is designed to shoot or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. They don't have to pull the trigger more than once. Machine gun. That's the federal definition. Starting on line 13, the last sentence, the term does not include any weapon or other item that is registered in the National Firearms Registration and Transfer Record maintained by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, or that is otherwise not subject to that registration requirement. So what that means is, under federal law, there are some machine guns that are still permitted. Two most, I think, common examples are machine guns that were manufactured before 1986. That was the year that the federal prohibition went into effect. That was a grandfather clause. So if you lawfully possessed your machine gun as of the date that that became effective in 86, then it would still be effective okay going forward. And also for military law enforcement, that kind of thing is also an exception for that. However, if you lawfully possess a machine gun, generally speaking, it has to be registered. So what I just mentioned, that registry that's maintained by ATF, National Firearms Registration and Transfer Record, so it has to be registered, serial number and that sort of thing. There's a couple of exceptions to that. That's why the last clause there, or that is not otherwise subject to the registration required. Some items that are made for research and development don't necessarily have to be registered. And also ATF has this process where they can sometimes make a technical determination that a weapon isn't actually a machine gun. And if that's the case, then it's not required to be registered. So those technical determinations and research and development are kind of parallel. They're tracked here. So that if you're not required to be registered under federal law, then possession is not illegal federally, and it would be illegal under the state provision as well. So
This may not be a question for you, but I'm curious how that sort of inspection, like that determination process works. Did someone come inspect the weapon in question? Like, how does that work?
good question, and you're right. I'm going to defer to some of the people who have more expertise on that one. Exactly.
It would be part of the registration process, right? Somebody would have.
Maybe so. Maybe someone would say I shouldn't have to register this, or maybe they make a technical. I'm sort of speculating, but maybe they look at it and say, this doesn't actually meet our definition that we're here about any frame or receiver of the weapon, et cetera, et cetera. But as rank speculation.
But this section is just an alignment with federal
Correct.
law.
That's the illegal under federal law already. Again, you have this language in place, then a Vermont state's attorney could bring a criminal charge in a Vermont state court for possession of machine gun, which couldn't be done now because it's not a violation of state law.
But if you had it now, you would be violating federal law.
Also,
Okay.
yeah. And that brings us to the end. I think that's the end of the walkthrough. It has an effective date of on passage. But otherwise, I think that covers everything I wanted to mention.
Curious about some things that are actually current law.
Can I ask you a question?
Yes, yeah.
Eric, I know that the House eliminated several provisions that were in the as introduced. Can you tell us what those were?
I can do my best to recall what they were. I remember that one of them was auto sears. So in addition to the machine gun prohibition, there was also had included a prohibition on certain other types of devices that can functionally make a semi-automatic weapon operate as an automatic machine gun type of weapon, including auto sears. And I think it was broad. It went through several different iterations. And but auto sears is one specific type of component that could be added to semi-automatic firearm that make it that would cause it to function like a machine gun. I think there might have been general language that also said any other item that could be added to have that result. So that was in the House version for a while before it was eliminated. Oh, thank you. Yes, exactly. There was the nuisance language in a sense. Several states have this. It was recently the subject of a big Second Circuit case challenging the constitutionality of New York's corporate responsibility nuisance statute. And that allows people to bring lawsuits for damages against firearms companies when the weapons they manufacture are used in criminal offenses on the basis of a nuisance theory, which is common law theory that something including used to interferes with someone's ability to
Some instances to be alive.
So yeah, that provision was in the House bill as introduced as well.
Thank you.
Yep.
Eric, I'm looking at page 5, line 17, as the person shall not possess a firearm. And then it lists all of the prohibitions.
Yep.
As well as both language.
Right.
And then I'm looking at the federal definition where it says a person is prohibited from shipping, transporting, receiving, or possessing. So theoretically, is somebody able to purchase a firearm but then not possess it if they're a prohibited person?
I think that the view at the time was that you would, if you tried to purchase it, then you would possess it, so that it would sweep you in without having, not that you couldn't enumerate that if you wanted to, but I think that was the idea.
And if somebody is, I'm thinking of the shipping or the transportation aspect of it, if somebody is a prohibited person and they're sitting in a car, somebody else who's in possession of a firearm and they're transporting that firearm, or they're just driving, would they be swept up in this as violating the statute?
You mean if the prohibited person, let's say, was a passenger in the car that had the firearm, or?
Well, yeah, if let's say there's a firearm in the trunk and maybe it's not on the person who's driving.
Right,
And they're transporting the firearm somewhere. What are your thoughts on that?
It's an interesting question. I think it's possible because that brings up the whole issue of constructive possession, right? So it's not necessarily that it's actual possession. I think it's generally viewed as within your wingspan. Constructive possession is something that you sort of have dominion or control over. For example, you can be in possession of something that's in your house, or it's upstairs. It's not actually on you as a person. We've talked about that before in this committee as well. So it is possible. I don't want to give a legal opinion on the top of my head as to the exact way that would play out in court. But yes, it's possible, particularly in the trunk of a car. I think that possession is generally viewed as pretty, with respect to vehicles in particular, that a trunk can constitute possession. But again, even how that question is resolved in practice often depends on the particular facts and circumstances of the case. But it could be constructive possession. Certainly can include situations where it might be in the trunk of your car, might be in another room of your house, might be some other way that you are exercising control over the object, even if you don't necessarily have it on yours.
And the other question I have is, and this is current law, if you remember the background, the context of this, page 6, line 4, person against whom charges are pending. Why is that pending rather than
Yes, that is also intentional. The reason for that is that federal law prohibits possession by anyone under indictment for a felony. In addition to the conviction. So there's the conviction stuff that's a whole separate category. If you're convicted of any one of those crimes under federal law, you're prohibited. Also, federal law has a separate provision for under indictment. So these people also are already prohibited under federal law. That list of 3 offenses there, if you're again assumed charges are pending. The reason those 3 particular offenses are there is actually relates to the violence of crime by juveniles law that you passed a few years back. If you remember, there was a long back and forth between the Senate and the House about whether to expand the Big 12 juvenile offenses. It went back and forth, and now it happened to include some other related criminal justice provisions, and that's what that sort of the part of the back and forth between the Senate and the House was, see, 2 of those pieces, B and C, drug trafficking and human trafficking, were also offenses that got added to a particular type of juvenile justice. So, part of that compromise between the Senate and House that those 3 were added here so that they would be prohibited on the basis of pending charges. Thanks. Yeah.
My question was after.
Any other
Yeah, just to go back on Senator Sheen's question, just for the clarification. I'm looking at,
Senator, I didn't hear the first part of
just to go back for some clarification on
Yep.
5,
Okay.
17 purchase a lot of that. I'm wondering if, and I know we don't like to use the knowingly standard, but if I'm borrowing somebody's car and I'm a felon and the firearm is in the trunk of the car with me not having knowledge of that, how open would that, how broad would that be as far as me being in possession of that firearm? I'm going to the store.
Yeah, that's a very good question. Because knowingly isn't included in the current language. Whereas some of the other firearm statutes you may recall that the legislature has passed over the last several years, for example, possession in a hospital building, possession in a polling place, those do include knowingly. Because we specifically talked about that he didn't want to cover a situation where a person, he wanted them to know both that they had it, that it would, and that they were in the location where the firearm was prohibited. So the fact that it's not included here, at least at first blush, does seem to at least raise the possibility that someone might conviction might happen whether or not they do it. But I don't know how the language has been interpreted. Maybe because it's strict possession and what requires courts have interpreted to require a knowing possession. Because generally speaking, courts don't want to create strict liability crimes without some sort of knowledge, some sort of science or mens rea. But I don't know that for sure. But I will look into it. It's a very good question.
Well, I could almost buy into there's a long arm in the backseat of the car, which plain view, but the locked container in the trunk of a vehicle, right? That it's a bit harder to throwing an intent just because it's in itself would be just that.
Yeah.
I mean, I can tell you, sharing details, if you are driving a car and you don't know there's a firearm in the front, you get pulled over, you are going to get charged with being prohibited person. I've seen that a few times.
Does it make any difference if it's your car or you borrowed a car?
It makes a difference. It can make a difference. I mean, all of the facts and circumstances to get taken into consideration. If it's your car,
You probably should have known if there was.
yeah. If you're borrowing a car and it's just you, you're probably still getting charged for it.
Okay.
But what are the possibilities of getting convicted?
Say it again.
What are the possibilities of getting convicted of that if you're borrowing somebody else's car?
I think it's very possible. That's what Senator Hashim was. I haven't seen happen. I don't know about the fixed part, but at least they got charged, but.
My answer is it depends. So,
Okay.
So being charged clearly like they're being convicted, so.
Right. So maybe the fact that the person that present facts and evidence that they wasn't their car, they borrowed it, they had no idea, maybe there's a better chance that they pleaded down or something.
so did you say that the courts would default the knowingly standards, even though it's not?
No, not necessarily. I just know that sometimes that, courts that in case law courts have sometimes talked about they don't want to create strict liability offenses. It's clear that's what the legislature wants to do. In other words, if you convict for something criminally without any criminal intent, that's atypical, not impossible. Atypical. I don't know how they would have delivered it here in this case. That's what I wanted to get to.
The other, but for
All right. Any other questions? Let me know. Thank you. Okay.
Good morning. All right. Thank you. Good morning, everyone. And McManus with the Department of State Attorneys and Sheriffs. We are on H606. Overall, our department supports this bill. There are two sections of the bill that were part of our 10 priorities that we had presented to you all at the beginning of the year. The first section has one of our priorities, which is creating a felony for the theft of firearms. I believe in the House side, one of the gun rights advocates said it best. He said, this section is going after the behavior that we want to prevent, theft of firearms. And that even though that person couldn't support the bill philosophically, they supported that this was focused on the behavior of the person. We have seen an uptick in firearm related crime in Vermont. And we very much believe that this will help our initiatives toward public safety to, no matter what the value is of the firearm, have it be considered a felony to steal a firearm. So we support section 1. Section 2 was not part of our initiatives, but we support the concepts that, again, focused on behavior. This is your second offense. Possessing a prohibited firearm, whether under section 4017 for being someone convicted of a violent crime, or 4017A, the person is prohibited if you committed the offense once, then you committed the offense twice, that your second offense would be considered a felony, not a misdemeanor. We support section 2. Section 3. Section 3 was the other part of our firearms initiative. Our department very much wanted to see that we added to the persons prohibited, analogous to the federal prohibitions, persons who have, through various issues, have wound up in court and been found to be in need of treatment. That their behavior has again focused on behavior. Their behavior has brought them to court either through criminal activity or a civil issue or concern, and the court has deemed them in need of treatment, and therefore we're concerned about that person having a firearm or access to a firearm. Our language, the state's attorney's language, state's attorney's and sheriff's language, presented is seen in the bill as introduced is broader than what the House passed. We understand that the House was concerned that the language that we had suggested, which was simply that a person not possess a firearm if the court has found that the person is in need of treatment, pursuant to section 4822, or has been the subject of a hospitalization order or a non-hospitalization order. We kept it simple there, as we felt that was most analogous to federal law. And as Ledge Council explained, we use different terminology in Vermont. We wanted to use our Vermont terminology, not the federal language. We felt that was closest to what federal law prohibits. There was concern on the House side that that would sweep up too many individuals. And the conversation went, I think, unfortunately, a little off track. Folks were talking about individuals getting outpatient treatment, but not coming back to the fact that this was a court determination. And I think folks were concerned that sort of anyone with a mental health diagnosis would be part of this prohibition. And that, A, was not our intent, and B, is not what this language that we had suggested, again, which is broader than what's in the version you have, but not as broad as the federal language. That would not sweep up those individuals. So we appreciate what the House passed, and if you feel it needs to be that limited, we understand that. We think it doesn't meet the needs that we have seen in the community for those who should not have access to firearms. Specifically, if you look at page 6 and starting at line 11, and again, this is the language that passed out of the House. The lines 11 and 12 is what was in our recommendation. That court has found a person in need of treatment. The House then qualified that and added "and." So you need to find the need of treatment and then not guilty by reason of insanity or be found incompetent. As this committee has heard over days and days with the forensic facility, there is a tremendous amount of time that goes by between the concerning behavior and whether somebody is then eventually found not guilty by reason of insanity or incompetent. If this language remains, the end, meeting those final events, we would have individuals who we have great concerns for their mental stability, and they would be allowed to have access to firearms until one of those two qualifying events occurred or one of the other subsections occurred.
So what you're talking about, how does it intersect with our red flag laws? Because we also have laws allowing police to remove and the court to hold firearms in instances where there is there's an intersection here and I'm just not quite sure what it is.
There is, and I'm very happy that Carolyn Hansen is in the wings.
Okay. So wait.
And so a little bit of an answer, and then I absolutely defer to Carolyn on the deep dive to the emergency, the UFO laws. That is definitely in play here. The scenario that concerns our department is, again, as you heard through your forensic facility conversations, when a person has been found in need of treatment, there's a 90-day revolving clock, right? And the Department of Mental Health can renew that 90 days or may decide that per their definition, this person is no longer subject to them. If the state's attorney's office is up to date on that 90 days and communication is very clear, we would be able to file an URFO and then go that route if we haven't already. Our concern is that it's very easy for these things to slip through without us having the timely information or being just behind on that timeliness. And that there could be again windows where we don't have the OPO yet, that somebody is no longer subject to these provisions. So we like the simpler language that we presented. Again, we understand if the legislature prefers to have this tighter, we just have reservations about that. But we wanted to just make clear to you all, this of course is a policy decision.
Kim, if I could ask you, so as it stands in this draft, it has been found by the court to be a person in need of treatment pursuant to section 4822 and then lists a series of other things, and you need one of them to add to being in need of treatment. What is your sense of how many uses that would cut out? What kind of numbers do you think is talking? In other words, going from your original language to this, does it render it utterly ineffective? Does it just cut it in half? Or?
It doesn't make it ineffective, and I would be hard to give you the numbers. I think it's more the concern of the timing, the potential windows there. Our preference would be to just, instead of end, is to add an or there. That, the court has found this person to be in need of treatment. So from that moment, right, that person is no longer to be in possession. Or later on, they've been found not guilty by reason of insanity. Okay, so we would just, we think that would capture, especially just thinking of somebody has been, again, this is coming from the criminal lens, right? There's the other section that is where it's the civil route. And if someone's been accused of a crime, there's already great stress in their life. We're catching them at such an unstable moment. And if they are out on bail, and now you've heard 1 year, 2 year, we're just concerned. And Senator Barr is absolutely right. There are other mechanisms, but I'm just concerned that we're going to let some incidents slip through that could be that we've seen to be quite dangerous.
And just a clarification on in need of treatment. What could that include? That finding? Who would that include?
So the definition, Jade, I'm happy to hand this to you. In section 4822, it's subsection 17. The definition for a person in need of treatment means a person who has a mental illness, and as a result of that mental illness, his or her capacity to exercise self-control, judgment, or discretion in the conduct of his or her affairs and social relations is so lessened that he or she poses a danger of harm to himself, to herself, or to others. And then it goes on to explain what a danger of harm, can be established by. So if a court has found someone, right, to be in such a state that they pose a danger to himself or herself or others, we believe like at that moment, the person should not be allowed to possess or have access or purchase a firearm, especially since the Vermont statute has the petition section. So if a finding's been made, you're prohibited from having a firearm. After that decision has been made, there is a mechanism to go back to be allowed once things have stabilized and you've shown the court that you're no longer a threat to yourself or others. We believe that provision would nullify any concerns that somebody who shouldn't be in this category somehow quote swept up into it. We think that.
Yeah.
And again, because the calm of coming back into court being able to assess what's going on, where things are, being able to make a decision.
And I assume the court is working with clinicians to assess both the legal aspect and the clinical aspect.
Yes, exactly. The board is asking others for those
Yeah, before we move on, there was also conversation earlier on regarding page 5, line 17. And the mens rea, well, there isn't any listed mens rea for a person who shall not possess a firearm. And there was also a point raised about if there was a knowingly standard, or if it should be a knowingly standard. Do you have any thoughts on that?
I believe the language is exactly the same in 4017 and 4017A. As
Yes.
far as right, the part of technically part. Yeah, a person shall not possess. I believe, as always, this is a decision for you all. I believe the logic behind that, as you know, for anything that is a liability crime, it is, the legislature has seen something that is, that just cannot possess it. You do not need to get into the mens rea section. That is, of course, and that it's clear, that that's your intent. From our point of view, we appreciate that. You either you have it or you don't have it. You don't have to explain whether you knew you had it. Especially with 4017A, we also put questions there about your knowledge. So I have to implement on this piece.
I think some of the context of why we were talking about mens rea was in the situations where somebody may be passenger in a vehicle being driven by somebody who has firearms in the front. They get pulled over, passenger gets charged for being constructive possession.
Well, if they were passenger, I mean, it's usually the driver, it's fully responsible for the contents of the vehicle, not the passenger. So I mean, there would need to be a little bit more detail there. Is it the passenger who put the weapons and but there would need to be more information there.
I think
An unlikely scenario.
the example we were talking about was the person borrowed the car and was driving.
I mean, again, yeah, technically, it would be in possession, but it's excellent argument against that.
Yeah, that would be a prosecutorial discretion.
Yes. Force.
Carry on. Sorry.
Oh, no, and I know you have a room full of people, section 4, from a public safety standpoint, we have no issue with the addition of machine gun language. Pledge Council stated, it's analogous to the federal language. I would suggest calling in some members of law enforcement. I'm not sure, and I had some brief conversations, but I was not able to do any sort of deep dive survey of whether law enforcement have weaponry that would fall under this definition, and whether or not there's a law enforcement exception. Currently, there's not in the statute, or whether we would need to have one, and or whether this would apply to all law enforcement. I do not have that answer for you. I just want to raise it as a potential issue, and that you might want to hear directly from law enforcement whether this is an issue for the departments.
Thank you. Any other questions for Kim? Yes, thank you.
Thank you so much.
Well, I'm excited to sit down. But before I begin, I just wanted to ask for a clarification because I listened to Eric's excellent walkthrough and the piece that I am planning to talk to you all about today. I didn't see that. Just, do you all have a copy of
So
that?
you're talking about the relinquishment amendment? Is
Yes.
that, yes, so. I may have,
I just want to make
I
sure
think
that you're.
John's Rose is gonna be testifying on that next, so. Yes, we do have that amendment in front of us.
Okay, I just wanted to make sure that, so, good morning.
Good morning.
I'm Carolyn Benson with the Attorney General's office, and I'm here to talk to you just about one small piece of this, which is new to the bill, but not new to the discussion, I don't think. And it goes back to a recommendation that the Fatality Review Commission made to look at the fact that we don't really have a compliance process in Vermont. So we've done a lot of talking this morning about people who are prohibited from having firearms and the fact that we're making sure that there's a court process that protects their rights and also protects the public and determining whether or not someone should have that privilege to have a firearm revoked temporarily in some cases, which is mostly what I'm thinking about, which is like a relief from abuse order, or as you brought up, Senator Urbo, or in more permanent circumstances where they've been convicted of a crime, all those situations that Eric went through. And the same with someone who has been on a hospitalization order or something like that. That's a temporary type of suspension. So what we don't have, and what the Fatality Review is interested in bringing to your attention is a process to find out, where is the firearm now? Did you surrender it to someone, and to whom? And to make sure that that's done in a safe way. Because we have had incidences in Vermont where somebody said, I'm going to leave the gun with my parents, or my parents have the gun, or my family member has the gun. And that is not a secure setting. And the person is able to gain access to the firearm, and it has lethal consequences. So it's a really important thing to look at. And in the last session, you all were kind enough to create a working group, which was housed through my office. It was the Firearm Surrender Compliance Working Group. It was made up of a very broad spectrum of folks. Kim was on it, folks from the network were on it, and FFL owner was on it, state police were on it. I can give you a whole list, but it was a really broad, but not too large group of 10 people. And then there were a whole list of folks that we were consulting with. And so we reached out to them and also asked for their input and got input from some of them. And what we were looking at is the compliance process. What can we do to move that forward? And the purpose, I'll tell you what the purpose says. So that was Act 64 in 2025. The purpose was to create a uniform process to ensure compliance with court orders to surrender firearms. The working group shall examine the statutory or policy changes necessary to create a uniform process to monitor compliance, support entities charged with storing and returning surrendered firearms pursuant to court orders, and identify a stable and reliable funding source for any additional resources needed to monitor compliance. So our goal was to create a workable statewide compliance model that would work in family court and in criminal court, and that makes sure that there is accountability of the respondents and defendants, and also addresses the safety needs of plaintiffs and victims and the public. And it also was to look at proper storage of firearms to make sure that they're taken care of and secured, and recommendation for any legislative changes needed. So that was our charge. And we began meeting right after it passed in July. And you authorized us to meet 6 times. We actually had time to meet 5 times. And we produced a report, which was required to be submitted to you in November of 2025. And you have that report. I think it was emailed to all of you. I hope you have that in front of you. But that contains the recommendations that I'm going to talk about today. And specifically, the thing that you're recommending that this bill now contains is language to change some of the provisions in 20 VSA 2307. And what that is back in time where I am on my notes. Back in 2013, you all created that statute, and it had to do with surrender firearms and how it would work. Unfortunately, it never really took off the ground. The idea was to have a partnership between private entities like FFLs that have room and the capacity and the knowledge to store things in a careful way, and law enforcement. And there were just some things like right out of the gate that didn't work well. And I will tell you a couple of what those things were. Go ahead.
Sorry to interrupt.
No,
I'm
it's
just
okay.
wondering procedurally, did this go before the House?
It has not yet.
Was there a reason for that? I mean,
Not-
in other words, just wondering if a report was issued that.
yeah. I don't know. I kind of have the same questions. I'm really happy to be here today, and I feel like it's like, it's a small thing, but it's a really important thing. And I don't really know the policy reasons or decisions behind where things are. Eric probably does.
You probably have a better background than I do.
Yeah, to respond to Senator Brew's question, it was purely time. It did get introduced as a short form, and then things got really backed up, and then the drafting deadline passed, and so there wasn't time to get it fully vetted prior to the 606 coming down here, so that was the only reason.
So just wanted to know if there was any kind of record in the House with regard.
No, it wasn't even discussed yet.
Okay, thank you.
But I'm happy to answer any questions you have about it today. So, so anyway, some of the issues back in 2013, they didn't contemplate at the time. It was thought that like individuals would store their firearms with FFLs. It wasn't really contemplated that police might want to use that storage. So the bill wasn't really written with that in mind. And as it turns out, I mean, we're going to address the perennial problem with these kinds of non-evidentiary firearms being collected by police agencies, is they are just so pressed for storage anywhere. And so that creates sort of a disincentive to collect the firearm, you know, as you can imagine. Not that they don't want to do their jobs, but it's just hard when you don't have anywhere to put them. So part of what this does is to make sure that it's transparent, that police agencies themselves can use this, as long as it's communicated to the defendant so they know where the firearm is stored. And they know up front that they're going to be responsible for storage costs. So what we're trying to avoid here is the state having to, you know, build some kind of new storage facility. Because if you do that, it's not only expensive, but there's a lot of federal regulations around taking in and releasing firearms. And the FFLs, they got that down. They do it all day long. So if we can partner with them and make that partnership work, we can help with the small departments that just don't have the capacity to store firearms and remove the concern they have when they go, for instance, to serve an ERFO and the person has 30 guns. We can remove the concern that they have of like, oh my God, now what am I going to do with these guns? Because they can't really put it in their place where they store evidence, because there's a lot of tracking kind of stuff you have to do with your evidence. And they're going to take good care of them, but you just don't want people kind of going in and out of evidence either. So it is important that police figure out what they're going to do with non-evidentiary firearms. The other thing is the bill back in 2013, it had immunity for law enforcement for acting in the regular course of business. You know, not they engaged in like gross negligence, but they had immunity for them. Didn't have immunity for the FFLs. And so that was sort of right out of the gate, a little bit of a non-starter for them to feel like part of the program. And the proceeds, in the event that somebody never comes to get these firearms that they're holding temporarily, the proceeds, they could deduct like whatever costs they incurred for storage, but then they had to somehow find this owner who had never showed up, because the rest of any other leftover proceeds from the sale of these guns had to go to that person who never showed up to pick them up.
Just to clarify, I'm
Yeah.
looking at the immunity on page 11, and it is immunity. So if they have a firearm that they're storing for somebody, and that person never comes to get the firearm, they disappear, and years pass and the FFL wants to sell the firearm, that's what the immunity is for?
It involves around the sale, but also just in the process itself. So they can't be sued because somebody, I don't know, I can't, I mean, people come up with reasons to sue people, right? So they have no protection if they took in a firearm and treated it appropriately. They have no protections from that. So I don't know if I'm answering your question exactly. I'm trying, but it's.
So this is just blanket civil criminal immunity from the sale of all firearms?
No, just the sale of firearms they've taken in for this purpose.
Okay, that's
And
what I
as
wanted.
long as they follow the process in the statute. So it's not just like any firearm they happen to have. And it's also not that they can just take it in and then do whatever they want. If they follow the statute, then they can't be randomly sued by someone. Because even if somebody doesn't have a good claim, I'm sure you know, lawsuits are expensive. And so you end up, causing these businesses to have to contend with lawsuits and costs. And we just don't want to add to that as long as they are treating them properly and following the process. And then there was also a problem with the fact that we decided policy-wise that we thought it would be appropriate for defendants to store their firearms with a third party, but you all added language that's currently in a statute that says unless the court finds that the relinquishment to the other person will not adequately protect the safety of the victim. So that was good, except that there was no process around that. So a lot of times if police were asking about a firearm, the person would say, oh, my brother has them. And then the court was like, well, there's nothing for me to do. The brother already has them. How do I know anything about this? I didn't authorize that. So this creates a process where what should have been happening happens, which is law enforcement or an FFL has the firearm until the court can have a hearing at which they determine whether or not that third party is even eligible to hold firearms. I mean, there was no background check. There was no verification that they even had it. So this creates a process where that, which is what should have been done from the beginning, that it needs to occur in court. And there's also a provision in there that it doesn't delay the court proceedings because, we want RFAs, relief from abuse orders and ERPOs, extreme risk protection orders. We want those to move forward in as fast a way as they can possibly. But we don't want those hearings delayed because the defendant doesn't have the third party in court today. So it does say if you don't have somebody approved right there at court, either because they don't have time or you don't have the proof to present, it won't delay the court moving forward with the final order, but you can still present your person. You just have to do it at another time. So that's kind of built in there just to make sure there isn't delay. So before I move into the substantive changes, I also just wanted to emphasize a very important point, which is quite different than the other things you've been looking at this morning. This is no new firearms restrictions. Want to make sure that everybody's really clear about that. This is not taking any additional guns that were not already authorized by the court to be taken. There is no additional regulation here. This is really a process piece to this bill. It's not really a firearms piece. It doesn't expand anything. And I thought I would move now to what's the changes are to 20 VSA 2307. But please stop me if you have questions. Our printer wasn't working this morning, so all I have are my comments. I don't have a copy of the bill and all that stuff. So you have to help me if you asked about it. Oh, okay, thank you. Particular piece of it. So we talked about the fact that it clarifies, the first thing it does is clarify that a hearing is required in order for a third party to hold firearms. And that the hearing, it's approval of that third party, it's not a basis to delay the hearing itself, but it's just sets up a process for it. And it explains that the third party does have to undergo a background check because the court can't run a background check. So the court needs somebody who comes in and says, I'd like to pull this person's firearms. They need somebody to run that background check, law enforcement or an FFL, and allow the court to see that this person who's telling them that they'd like to hold the firearms is actually eligible to hold them. Another change is originally ammunition was included in the bill as something that could be held by the police. And we heard from police agencies and we also heard from FFLs that the ammunition just doesn't make a lot of sense because a couple of reasons. It's not regulated the way firearms are. So you can walk into a hardware store and buy ammunition. So it's not really providing any additional safety there. And it creates a burden because, somebody can have a lot of ammunition and it's heavy and they just didn't want to be charged with storing it. And from the state police perspective, they explained that ammunition is actually hazardous waste. So it entails a lot of difficulty in disposing of it. So for all those reasons, ammunition was just taken out to make this workable for the people who are going to be doing the work. It creates an acknowledgement form, and this is really important so that when a defendant is given an ERPO and told they can't possess firearms, or given a relief from abuse order and told they can't possess firearms, there is a form that they will indicate where their firearm is. Either that they have firearms, don't have firearms. If they have firearms, where's the firearm? It lets the court know that the defendant has surrendered it to someone. And it just creates a record that we can track that way and provide some accountability. And it's really important for people in court to know that the court's going to ask about that. Because if you think about it, the court's just up there saying, you can't do this now, see you later. And the person's there saying, well, I have 3 firearms. And the judge is like, not responding in any way to that. It doesn't send a very good message. We want people to know that we do care that they surrender their firearms and we expect to know where the firearms are surrendered. So that's a process that would be worked on with the court. It also clarifies that law enforcement agencies, and I mentioned this earlier, that they can store firearms with an FFL. So if you're a department with 3 officers and no storage, very small department, you don't have to create storage for firearms. You can partner with your FFL and have them provide that storage for you.
Is that only for non-evidentiary?
Yes, absolutely. No evidentiary firearms can go there.
And you're probably gonna get here. I'm wondering, this is all dependent on a voluntary participation by FFLs.
Yes,
So I see on page 12 that DPS would have to adopt a policy that encourages FFLs to do this.
yes.
But did the committee take testimony from enough FFLs?
We have an FFL owner on
Yeah.
the committee, Henry Perro, and a lot of this, his handiwork is a lot in these, some of you'll see. And he gathered information from other people. He told me that lots of other FFLs actually call him when they have questions around things because he happens to have one of the bigger shops around.
Yeah.
So if you all wanted to hear from Henry, I'm sure he
Well,
would be happy.
just
to-
specifically, I was wondering, did you have data that would suggest that this would be successful? Because I could see an FFL saying, I don't want to be a part of
Yeah.
taking or holding somebody's guns. I don't believe in it. So I'm not going to do it. We have like 580 FFLs. Do you have any sense of how many might voluntarily? Because if they don't, none of this will
Yeah.
fly.
Well, we have, I think, 8 or 9 right now that have been participating. So part of what's on the state police website, because this program has been ongoing since 2013, is an interactive map. And that's relatively new. It's a terrific thing the state police did to create a map of these are, you don't have to call someone up and call 10 different places. You can look at this map and see a place that's agreed to store firearms, how to contact them, what their phone number is. We're hoping to add to that. I mean, they made an effort a couple of years ago to reach out to each lieutenant at their barracks. They would have somebody reach out to their local FFL and encourage them to participate. And a lot of the time they would say, I don't want to do that because of X. And it was usually the things we've addressed in this bill, we've tried to address, which is like the immunity issue. The fact that the proceeds they couldn't keep the proceeds. They had to try to find somebody that they hadn't had any contact with. So kind of from the get-go, they had a lot of objections to it, and we did our best to remove those objections. But I think that it's still an open question as to how successful this partnership will be. I mean, a lot's gonna depend on the Department of Public Safety working on rebuilding that relationship. Because I think when people feel like wasn't good to start with, it takes some time. And I think having Henry participate in this and giving them a voice, I hope that they feel heard by that, and that I hope we've met their concerns. And if we haven't, I hope they'll speak up now and let us know if there's something we missed. All right, we talked about the acknowledgement form. We talked about that, in fact, that it clarifies that law enforcement agencies can store with an FFL. We want to make sure that that's very clear, provided that the defendant knows about the transfer. We don't want defendants thinking that Colchester PD has their firearms when really they're with Henry Perro. So there is a process that we created where they would be notified of that. They'll also be notified if you want to have the court consider a third party to hold your firearms, who might, for instance, hold it for you for free, family member, someone like that. There's a process in place for them to come forward. I mean, storage fees are pretty minimal. You all set them. We first looked at this bill and there's no changes to those. But for some folks that can be prohibitive too. So there is a process for them to come to the court and ask that a third party be approved to hold a firearm. And we just want to make sure that it's someone who has the capacity and willingness to hold the firearm for them. FFLs can't be asked to hold a firearm if the order is just a temporary order. And the reason that is because when you all first did this storage law, it said that you can't be charged any storage fees until the order becomes final. And so we wanted to acknowledge that fact that we don't want police agencies, for instance, using an FFL to hold firearms in a temporary order situation and then have the final order get dismissed and they don't get reimbursed for their fees. So we just changed it to say that they are not required to hold a firearm, well, not required anyway, but they can't hold a firearm for a law enforcement agency until it's a final order. So they will just have to figure out a way to exist for those 10 days until it's the final order. However, it's clear in there, an exception in there, that if the defendant wants from the get-go, they want their gun stored with an FFL, they can certainly do that. They just have to agree to pay the storage fee. So, it's not that they use it, it's just that it has to be their choice to use it at that stage. And this is a really important part of this too. So we added provision that at least 24 hours in advance of the release of the firearm, because like I said, these are situations where it's a temporary thing. It's for as long as the order exists, as long as the court has authorized the IRFA to last, as long as the court has authorized the relief of abuse order to last. When that ends, the firearms are going to be released. And we want to make sure that the victim receives notification that that's going to happen at least 24 hours in advance. And so law enforcement would be providing that notice. The next piece has to do with just kind of squaring things up with. Originally, it said something like the firearms have to be returned within 3 days, consistent with federal law. And the FFL owner pointed out to us that they thought that could create a situation where they were expected to give a gun back when they weren't actually able to give it back under federal law. It was complicated. So we just changed it to say that there is a 72-hour window in which the firearm should be returned after the background check is complete. And that's the way they do it right now and complies with federal law. And they just wanted to make sure that this law, in terms of releasing firearms, was consistent with that, with the way they do business now under federal law. If the owner does fail to collect their firearms, they can be sold and the proceeds kept by the storing agency. And this is done in some other places around the country. And I've actually heard from some police departments that this has been a source of revenue for them and sometimes allowed them to purchase like some equipment that they otherwise weren't able to, that didn't fit within their contract or what have you. So we're hoping that by allowing them to keep the proceeds, that maybe we'll build in some incentive, like you were saying, to participate in the program and also make this more workable for law enforcement. We've already talked about the immunity, so it makes the FFLs get the same kind of immunity that law enforcement gets for storing the firearms. Just making that consistent.
I'm sorry, just a question, building off of the answer you gave to my last one. So if I heard you correctly, you said you currently have 8 or 10 FFLs that have agreed. How did the committee find those 8 or 10? Did you advertise?
We did. That was all DPS. I mean, DPS, when they were handed this program to administer, they collected data. And then I think they've done a little bit of reach out to make sure that the FFLs were aware of this and to try to get them signed up. And then it's just a matter of making sure that they want to continue to participate. So the ones that are there was only maybe like 2 or 3 for a number of years. And then about 2 years ago, there was a major at the state police who took a real interest in this. And I worked with him and we did some just kind of reach out to some of the FFLs. And he made sure that each barracks reached out to the people that knew them and asked if they'd be willing to participate in this. And I think a lot of business owners, they want to be a positive presence in the community, right? And do something as long as it's not going to burn them down the road. So that's basically what we're trying to prevent.
Yeah.
So I think there needs to be more reach out. I think there needs to be regular reach out. And I think there's probably some folks that could assist. I mean, this is just me. The Department of Public Safety can decide how they want to go about this, but there may be folks, that are at the Department of Health, for instance, who could assist with some of that type of work.
And I guess where I'm going is if DPS reached out to all 580 something and 8 said yes, that's a data point that's very important. Because it's a very low percentage and you'd have big geographical distances that people might have to travel to make sure that their gun winds up where it should.
Yeah.
So as we go forward, I just don't want us to lose sight of the fact that it's all built on voluntary participation, which at least so far is not yielding a lot of cooperation. Some, and maybe.
I agree with you. No, I like that you're pointing that out and I agree with you. And I think the reason I'm optimistic is that this was not crafted appropriately the first time around. And I think we've made real effort to try to craft it appropriately. And I think you also have to keep in mind that even though we have that many gun sellers, many of those don't have any ability to store. They're just little mom and pop kind of places. So I'm not exactly sure what the number looks like of the ones who actually have storage capacity, but it is a much smaller number. And I just hope that by showing them and actually putting it into the statute that they're would be supported and encouraged to participate, that we kind of set the tone for making this work. I think originally there were a lot of regulations because the state police wanted to make sure they had everything. I don't want to speak for them. There's people here who can speak for them. But there was a lot, the regulations were pretty hefty that the FFLs had to be able to follow. And they cut those down a lot, like made them much simpler. So I think we're moving in the right direction. And I think that we're just gonna have to hope that we build this and it works. And if it doesn't work, we'll come back and try to fix what doesn't work about it. And I don't want to take up too much more of your time. Let me see if there's anything else. So we talked about the immunity, including immunity for sale. Law enforcement didn't have that immunity before, so this creates it. If they follow this process and they sell the guns, because the person's never responded, they can't come back and sue them and say, oh, I thought you would have them 3 years later.
This may be directly in there, but what's the timeline for that? At what point do they decide the gun's the best weapon?
It's in the statute, but I think it's 90 days that they have. If they haven't paid the storage fee, and the FFL or the law enforcement agency has to send a certified letter to their last known address. It's stated to the defendant has to keep them apprised of an address or a way to contact them. So it's built in that there are steps to make sure that they know that their guns are eligible to be picked up. And it's just if they ignore that, and I believe the time period in the statute right now is 90 days.
I don't know if you touched upon it, but say there's $500 in storage fees and gets to the point after the 90 days and you sell $3,000 worth of guns. Does the FFL or law enforcement get to keep that 3,000, or do they have to only retain the amount that the storage fees cover and then maybe costs associated with the sale?
They get to keep the 3,000.
Okay. Okay.
Yeah, it's all the proceeds from it. So that's a change in the statute. And there's a new section at the end that creates a model policy. So not us creating it, law enforcement themselves through the Law Enforcement Advisory Board would create this model policy. And that would make sure that law enforcement understands a couple of really important things, that they understand their legal removal of firearms from the scene of a domestic violence incident, how to do that legally, steps for inquiring. So when they serve an order, that they don't just hand the person the order and say, okay, this tells you can't be 100 feet, that they go over the firearm part of it as well. And they ask about the firearms when they're serving the order, and creating sort of a process for how they would do that. A process to notify the plaintiff about the service of the order and the relinquishment of firearms. So making sure that when they do surrender firearms, that they're told that the firearms have been surrendered, so they can factor that into their safety. We're trying to speed up. I know that's supposed to be done now. And then there's some part in there about law enforcement thinking about how they're going to collect data around this to make sure that that we are able to monitor that on the number and the type of firearms that are collected. And also provision is there's a whole separate section that was basically kind of copied from this section I've been talking about that deals with ERPOs, and that's in 13 VSA 459. And basically it cuts out most of that statute. It just says refer to 20 VSA 2307 for the process of making sure that firearms are surrendered in an ERPO situation. So it just aligns the two things, so we don't have two different statutes with potentially differences between them. I think I've covered everything. Any questions?
Any other questions?
Thanks for the quick one here. In reference to the FFLs and law enforcement, once the court of order, who brings the guns? Once the court's made an order, who brings the guns? Does the FFL come and pick them up as law enforcement transport them? Because if you're talking about the tracking system mechanism, we have data, simple database that everyone's on the Belcourt system now to go to state law enforcement. I don't think it's too hard to set up a database and on this happening is to make the entries in there.
Yeah.
And then the FFL will notify law enforcement when in fact the gun was released, or I don't think I can figure it out.
I think I'm following your question, but please tell me if I don't answer it all the way. So the first part about would the defendant take it there? No.
No, law enforcement.
Law enforcement would take it there. Yes, not the defendant. Good. We're in agreement on that.
Yes.
So the law enforcement would collect it, and then if they're planning to sort with an FFL, they would transport it to the FFL. And then what was the next part?
You said you wouldn't have a problem with actually tracking the guns as far as releasing whatever else if law enforcement brings it there. They're all on the same Belcourt system now, so they simply set the data. And I'm not telling law enforcement what to do here. It's as simple as setting up a database, and then the FFL can notify law enforcement when in fact the gun was released. And it seems like a simple process here, but maybe there's more to it than meets the eye here. So.
Yeah, we got into a pretty long discussion in our committee about Valcourt. And this information, of course, whenever law enforcement goes out on a call, something goes into Valcourt, but that doesn't mean you can pull it out or that you can connect it with the order. So there's also a process form that law enforcement fills out that goes back to the court. And there's already some questions on that now, like, did you collect any firearms? So figuring out a way that we can mesh those two together. I mean, I think there may be a way, possibly a way to have this information available and retrievable if it's captured on the surface of process form. But I think that there needs to be more work done around that. I mean, people raise some very good concerns about being able to access that data and how they would track that data. So basically, this is just saying that we want it done and then figuring out whether Valcourt can provide that vehicle or, the court documents to provide that vehicle. I think that's still a question that needs more work.
Thank you.
Welcome. Thank you. Appreciate the time.
I'm gonna grab Valeria, we're gonna skip over one and then move back around. John, say that's all right.
Waiting for a response.
Mr.
Oh,
Chair,
yeah,
I'm just wondering, I have an amendment myself, and I'm wondering what order you'd like to proceed.
we can do that towards the end so we can get to our witnesses. Pardon? Oh, thank you.
Why?
I'm mindful of the jaws. Because I think you need a bigger boat. You know, other people in here. Tends to happen that with these kind of bills. Anyway, I'm Matt Valeria, I'm the Defender General. And I'm going to basically tell you the same story I said in the House. I have no dog in this fight. But what I am going to try to do is explain to him that the bill is passed as it is. And one of these cases came up in our office, how we would fight it. Okay. Sure, as you know, probably had a bunch of people already talk to you about the the primary constitutional right to bear arms under both the Vermont and U.S. constitutions. And it's no different than a right to free speech or any other right that is, in our constitution. So while you can regulate around the edges of it, you have to be very careful and very narrow in the way you approach firearms and limitations that you put on those rights. I will say first that I really have no comment on section 1 at all involving the adding a crime for stealing a firearm. I had a felony against this. I always wonder about like proportionality and sentencing. When you have a 10-year felony for stealing a firearm, which would be more than like manslaughter. But you can do it. It just, sometimes the proportionality of penalties regarding crimes. You might want to think about that. Obviously, the kind of the guts of the bill are the portions on page 6 and 7.
Before you get to page 6 and 7, I wanted to go back to section 2, page 2, and the new felony offense there. I know we hear this at least with drug offenses and property crimes, that increasing penalties or felonizing certain offenses doesn't necessarily deter the conduct. Do you have any thoughts on that? I mean, do you perceive this deterring possession or just having a harsher penalty for it after it happens?
I mean, there's no evidence of the criminal law to present that. So it's no different with this as anything else. I mean, in just as a case of what is the current value of sentencing? next to zero. They've done studies of this all over the nation. You know, this is about, showing the public that you're serious about it. This is about, for those who, in certain instances, you know, perhaps sex offenders or murderers or the like, where you have to isolate them and take them off the street so that, you know, that in and of itself creates public safety. You know, the penalties that are out there, if they don't deter already, you know, what's the difference between you know, the deterrence of a 2-year, incarceration versus a 3-year? It's, you know, from a, you know, deterrence and all, like I said, all of the studies about deterrence, it doesn't do anything. It's not really, you can do it. Yeah, I don't think changes anything. At one time I said it's years just we were talking about, might have been here, but we were talking about, drug trafficking, and he, suggested that maybe $100,000 fine, for drug trafficking. And I said, well, I can make it $1 million. And he said, okay. And actually, I think it's $1 million. Now, but, with the number of drug trafficking, crimes that I see come across my desk for reassignment as we arrest, you know, dozens of people a month on the charge, I don't think the fine is deterring anybody. And it's, you know, it's a long sentence too. So in any event, I'm not trying to stop that. I'm just saying it's not, you asked. So.
Yeah, no,
Yeah. Yeah. So if you go down on page 6 and you look at, he's really starting at, lines 11 through 19, and sitting on the next page, that's where there is areas where somebody could be charged with a crime for possessing a firearm. And what you have to do is, again, try to be as narrow as possible and get at what you're really trying to get at to regulate this. People who have been found in need of treatment or have been found not guilty or who have been incompetent to stand trial or who are subject to a commitment order or an order of hospitalizations are not in and of themselves necessarily a danger to themselves or others. That you can be incompetent to stand trial because you don't understand or are unable to understand or cooperate with your lawyer. You don't understand the role of the people, but you're perfectly competent to hunt, for example. What I warned the House about was creating a bathtub that is so big that you are including people who you don't need to include in a bill that's intended to curb people who are dangerous relative to firearms. And because it is a primary constitutional right, you have to make it as narrow as possible. I have an example, of course. I have a tenant who was in the military for 20 years, and he served a number of tours in various theaters of war. He came back, his mother passed away, and he had a mental breakdown, ended up hospitalized, and it was committed for a relatively short period of time. There wasn't a violent situation. The one thing that actually tended to calm him down is when he spent time in the woods hunting, and felt good about that. Under this, whether he was subject to an order of hospitalization or non-hospitalization, he could be potentially caught up in this bill.
So,
Matt, sorry to break you off. Just to clarify, so the AG's office, no, I'm sorry, the attorneys and sheriffs suggested making the and on line 12, page 6 and or. But right now, the current language is they have to be found to be a person in need of treatment and one of these other things. So in your example, if the person had not been found to be a danger to themselves or others, they wouldn't fall under the language that passed the House. So are you arguing against what the attorneys and sheriffs proposed or against this language as passed the House?
I'm commenting on the type of thing you need to be aware of, and I'm not particularly talking about the language itself. Because this thing is an evolving working process. I'm not really concerned about the attorneys and sheriffs or anybody else who's testified about it. There are two parts of how you look at these constitutionally. One is on its face, is it constitutional? And the other is as applied, is it constitutional? So when we're looking at this, we're going to look at this. Are you bringing into that, a baby that you're not intending to throw out when you bring it? All I'm trying to say here is that when you're doing these things, you need to look very, very narrowly. These don't, and I'm not sure that how this is going to come out. I never know. I usually come in and talk about these once and say, look, whatever you do exactly what you say you want to do. Don't expand it to a point where it's going to capture people that you don't want to capture. And there is if you're in a situation where somebody has, let me just kind of skip another issue. If you fall under this category, there's sort of a nonsensical sort of result. You've been found incompetent to stand trial. And then the result is, and you possess a firearm, and then the result is a crime.
You've also been found to be a person in need of treatment, is a danger to themselves or others.
The point is, if you're not competent, how are you any more competent to be charged with crime? To me, there should be a different result. There should be an injunction, a seizure of the weapon. There should be a part of your mental health order should include that you can't purchase or possess firearms, that sort of thing. It doesn't make sense for somebody who has been adjudicated incompetent that the result of having a weapon is that you are charged with a crime when you're already incompetent. You're already out of the jurisdiction of the court. It doesn't make any sense. Now we do this. This is a general observation. We do this all the time. We have people who have just been found incompetent. They end up committing some other activity. Law enforcement brings them in. They get charged with a crime while they're under an order that was part of their finding of incompetence. I've made suggestions about this in the past that really have gone nowhere. So, with administration and with others, is that Department of Mental Health has to have, in my view, an affirmative ability that social workers who focus on treatment, who follow up with people who are under orders of non-hospitalization, to ensure that they are complying, akin to probation officers, but not with the punishment, aspect that the Department of Corrections has. So when you see somebody who is not taking their medication or they are starting to decompensate, they can go back in, modify that order and say, I would like to have would like to convert this order of non-hospitalization to a hospitalization order, or other conditions that would ensure that that person is following the order. I don't think the Department of Mental Health is particularly interested in it. It's gotten like no traction, so I doubt that anybody else is interested in it. But what we end up having to do then is depend upon law enforcement to interdict these folks, and then they end up, the only place law enforcement really knows what to do with them is they bring them into the criminal system, which is what law enforcement does. So to me, the result of a violation of these sections when somebody's already been adjudicated, the insanity thing's a whole other issue. But I'll talk about that in just a second. But it doesn't seem to follow that the result of being incompetent is that you get charged with a crime. There should be another result that is civil in nature, not criminal in nature. To me. And again, what I'm pointing out here is ways that we're going to look at this when it comes to class act deaths. If you do this, you do what we respond to. This is what lawyers do all the time, is they respond to the things that are presented to us. The finding of its finding of not guilty by insanity for violent crime. First of all, I've actually surveyed our entire system, and we go back over 50 years, and nobody in Vermont that we're aware of has actually been found not guilty by reason of insanity by a jury in the collective memory of the defense bar. When these things arise, it's usually because both the prosecutor and the defense recognize that the person was insane at the time. That, however, is at the time of the offense. That is it's like a snapshot. It's a point in time, and it could be the result of some traumatic incident, a psychotic break. It could be any number of reasons why you are insane at the time of a particular offense. Where before the offense you weren't insane, after the offense you're not insane. You might be, or you may potentially be insane at some other time, which I guess any of us could be. In any event, this depending on how you word lines 11, 12, and the requirements, as Senator Groot pointed out, the key to me is to make sure that the person who is potentially subject to this criminal liability is one who would be a danger to themselves or others, as opposed to just having had a prior order.
I think that's the language we're looking for.
Okay. And that's much narrower, obviously, not obviously, but it's much narrower than the bill that's originally introduced in the House. There was also originally there was these, what I just call the alcohol, which is you can get relief from your disability by petitioning the court. That was out for a while, now it's back in line 4, so page 7. So that's good from a constitutional standpoint. Person at least would have the ability to go in and get relief from a firearms disability. the version I originally testified on did not have that in there. I suggested that consistent with federal law, that be put in there. So, I don't have any position on the bill as a whole. You know, how this is going to apply, and I don't have any comment at all on the definition of machine guns and that kind of stuff. I'll leave that in the books. These tend to be very fact specific when they arise in our context. So you may see challenges to the face of the law as it comes up, but it's always connected to facts. It's not just, nobody's going to sue and try to enjoin the statute blatantly on its face as it's written. But when it arises in a particular case, then we'll know. And lawyers are going to raise both sides of it, whether or not the bill is, the statute at the time is unconstitutional on its face, and you're always going to raise that issue. More likely, however, it's going to be how it is applied in any particular case. And then you're really going to determine whether that person is one of the babies you've thrown out with the bathwater or it's something else. And so, that's my general feelings about the bill. We don't, I will also say that our United States Supreme Court has been notoriously unpredictable recently in these types of things that advocates on both sides are looking at and saying, hey, they should have gone a different way. And I can't predict what our U.S. Supreme Court, and I asked our appellate division, and they said, there's a general trend to reaffirming rights to firearms and to limit impingement on them. But there are specific instances where you'd think that they would and they didn't. And so predicting how it might come out in any given situation is very, very difficult. It's a real conundrum, honestly, for lawyers, because one of the things we like to be able to do is kind of look at clear law and tell our clients, this happens, this is what this is what you do, this is what the result's going to be. Or if a case comes in, we can give them some prediction. We don't know. The appellate division doesn't know. I look at the case law, I don't know. So whatever happens, you can be assured that there would be litigation over the change. And what will happen next, I don't know, but we'll find out, because that's what our job is. So.
Thank you.
Any questions?
Great.
Thank you.
No problem. Thanks for having me here.
Morning, John. Thanks for your flexibility. I had to switch around a little bit here. But the floor is all yours. If you could just identify yourself.
Yeah, thank you. Sorry, I'm getting a little bit of crosstalk here through my speakers. I'm not sure where that's coming from, but yeah, thank you, and thank you for the flexibility in allowing me to appear remotely. My name is John Rose. I'm the Solicitor General at the Attorney General's office. As Solicitor General, I'm a litigator over here primarily, and I'm responsible for overseeing all the offices, appeals to the Vermont Supreme Court, the Second Circuit, the U.S. Supreme Court, and I also oversee significant trial court litigation. So that includes constitutional litigation and litigation involving sort of challenges to state laws. I'm typically involved in some way or overseeing those cases. So I understand you all asked me over here to give a little context for the law, some constitutional context for the law. So I'm going to try my best not to make this into a constitutional law lecture. But I did want to just kind of go through some of the basic principles over the years and sort of how I'd see those generally as applying to the law. The caveat here is that Second Amendment jurisprudence is still kind of a new thing. The Supreme Court only recognized individual Second Amendment right in 2008 for the first time. And so, the lower courts, and we've only had 4 Supreme Court decisions, including that one on the right. So the law is still evolving a little bit. It's working its way through the lower courts, but we do have some general principles, and I'll share those with you as they're, relevant to the to H606. So the first was, and I'll walk through those cases a little bit. The first was the Heller case in 2008. That was a challenge to Washington, D.C.'s law that barred people from owning handguns in their own home. And the court said, yes, there is a Second Amendment right that belongs to individuals. The central concern of that right is self-defense, and owning a handgun in your own home is squarely within that right. And so that was all the court did in that case. One thing it said in that case that's of particular relevance today is it said, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, and several other things like sensitive places like schools and churches, things like that. The other thing they said in that case, and this is sort of foundational to Second Amendment law right now, is that they said, we think the limitations on sort of, dangerous weapons are supported by historical traditions of prohibiting the carrying of dangerous and unusual weapons. So those are 2 sort of cornerstones that I think courts have been pretty uniformly assuming is that, whatever restrictions there are on firearms regulation, barring the mentally ill from possessing firearms, and restricting sort of unusually dangerous weapons, and machine guns are sort of the prototypical example of that, have always been part of it. The next case in the line was a case called McDonald versus City of Chicago. Another sort of, that one's a little bit more esoteric in that it was, the question was whether the Second Amendment applies to the states. And the Supreme Court said that it does. And it bars states from regulating, from violating their citizens' Second Amendment rights to firearms. The third case was the big one. That's the Bruin case that I'm sure everybody here has heard of. What Bruin did was establish the test that courts are supposed to use when they're looking at Second Amendment rights, and it's a 2-part test. The first part of the test is, does the Second Amendment's plain text cover the conduct that you're regulating? Does this involve the right of the people to keep and bear arms, basically? So that's a lot of litigation over what's an arm, who are the people, and sort of what circumstances would have fallen within that definition around the time of the founding, or for technical reasons around the time when the 14th Amendment was adopted in 1868, I believe. And then, so that's part 1 of the test. Part 2 of the test is if the regulation falls within the text of the Second Amendment, the government has to show that the regulation is consistent with the nation's historical tradition of firearms regulation. And so that's the part where we're looking into history and trying to figure out whether at the time of the founding or at the time of the adoption of the 14th Amendment, whether there were some laws that were sort of analogous to the laws that we're trying to pass today. So Bruin involved sort of firearms licensing, so it didn't really address the categories that were identified in Heller about the mentally ill and dangerous weapons. That wasn't really part of that case. And so it didn't really touch that language from Heller that says, of course, we can regulate the mentally ill and we can regulate sort of unusually dangerous weapons. The fourth case did touch on some of that and touches on your law a little bit. That case was last year's decision, I guess 2 years ago now, the decision in the United States versus Rahimi. And that was a case involving a domestic violence restraining order and whether a person could be disarmed while they were subject to a domestic violence restraining order. And the Supreme Court, I think in an 8-1 decision, Justice Thomas was the only justice who dissented, held that the state can do that. And the key there was, here's what the court said. When a restraining order contains a finding that an individual poses a credible threat to the physical safety of an intimate partner, that individual may, consistent with the Second Amendment, be banned from possessing firearms while the order is in effect. So Rahimi sort of, was based on historical laws that banned people from carrying guns out in sort of with dangerous intents or with ill intent toward people. And so the court said there was a history and tradition of that. I think one note that the court made in that decision that's relevant to your law also is it said, we don't suggest that the Second Amendment prohibits the enactment of laws banning the possession of guns by categories of persons thought by a legislature to present a special danger of misuse. And so, when we're looking at particularly sections 3 and section 4 of your bill, I'd feel pretty comfortable under those precedents that, we'd have very strong arguments that they're constitutional, sort of under the plain language of Heller, which was reaffirmed by Rahimi. And that's because, we have in both circumstances, in the case of section 3, we have a finding that a person is mentally ill, and even further than that, a finding that a person is dangerous and a person in need of treatment. And so we'd feel very comfortable defending that restriction under that language I quoted from the first original Heller decision, which sort of made clear that laws banning the mentally ill from possessing firearms are constitutional. And I think probably the rehabilitation provision and the ability of a person under state law to go to court and petition to have their rights restored would even further support that argument. On section 4, your machine gun ban, like I said, the machine gun ban was sort of one of the pillars of the reasoning in the Supreme Court in Heller, where they said that you can still ban dangerous and unusual weapons, because they cited an earlier case from the 1930s where the court did look at the original federal machine gun ban and said, yeah, of course we can regulate machine guns. And so I'm not aware of any decisions finding machine gun bans unconstitutional. I think there's been some litigation at the federal level about what exactly is a machine gun for purposes of the federal statute. But I don't see any, a real viable constitutional challenge to that. So that's the whirlwind overview. I guess the headline is that we're acting in two areas that we think are pretty squarely covered by the court's recent Second Amendment precedents. So, as a litigator, I'm not here as a policymaker, but as a litigator, I'd be pretty comfortable defending the law. And with that, I'm happy to answer any questions that anyone has.
Thank you for your time. Appreciate it.
All right. Thank you very much.
Good morning. Lily Glitzerman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. And similar to Assistant Attorney General Carolyn Hansen, I'm getting somewhere on my computer screen. And here to speak in support of the proposed amendment to H606 to codify recommendations from the Firearm Surrender Order Compliance Work Group. As you heard from Carolyn, these policy recommendations were developed through a very thoughtful and collaborative process, and we support advancing them this session. Firearms injury is the leading cause of domestic violence homicide in Vermont. And in 2024, 9 out of the 14 domestic violence-related homicides involved a firearm. That's why we have longstanding state and federal laws in place to protect victims that may risk of harm. And as you heard, under current law, certain defendants, as well as individuals subject to civil relief from abuse orders, can be legally required to surrender their firearms for a period of time. But there is no uniform process for carrying out or monitoring these court-ordered relinquishments. And the lack of compliance with these conditions really reflects administrative systems that are fragmented and need procedural update. Coming forward to request a relief from abuse order is very difficult for a plaintiff survivor. Asking a court to order firearms relinquishment can be even harder. It often reflects a survivor's true desperation and fear. And it can also often reflect their trust that the system will protect them. But too often that trust is broken in our current system. Relief from abuse order is an important acknowledgement by the court that a survivor has been abused and that there is a risk of future abuse. These orders include court-ordered conditions needed to protect a survivor's safety,
But an order is really only a piece of paper unless our systems ensure that the conditions are clearly understood by defendants, complied with, and enforced. We see survivors harmed by defendants who were ordered to surrender firearms but did not understand the order, did not abide by the order, and did not receive needed follow-up to ensure their compliance. And often survivors experience very extreme stress because they have limited information about whether firearms have been relinquished and they don't know whether they're safe. The provisions in this amendment are procedural improvements to ensure that our existing laws operate as intended. There are consensus recommendations among a very diverse group of stakeholders and the firearms surrender order compliance work group. And we're very deeply grateful for the work of these members. It was good work, in particular to Carolyn, who chaired the work group. We thank you for the opportunity to speak to the committee today and your consideration of this language, and I'd be happy to answer any questions.
Thank you. Committee, any questions?
Thank you.
Thanks, Tracy. Okay, so next up, we have 3 folks from every town. You guys have a rough estimate of how long collectively you'll need?
You speak for myself, 5 minutes, 4 minutes.
Okay, and I'm not trying to condense your time or anything. I just want to know just for future stuff. So if you need more than 5 minutes, it's good. So, okay, so Susan.
Suzanne Lurie.
Suzanne.
Thank you.
Please feel free.
Good morning, everybody. Being here. My name is Suzanne Lurie, and I live in Charlotte. And I'm here today as a gun violence survivor and as someone who believes we can and must do better. My personal story is not unique. The consequences of gun violence have far-reaching ripple effects that impact the lives of too many people. In 1987, I was in law school when I received a call that would change the lives of my family forever. On the day before his 58th birthday, my father, a neurosurgeon, was the victim of a premeditated murder in our home by a patient. My mother was also shot. She survived her injuries, but later died in large measure due to the trauma. She relived that horrible event over and over, but could no longer distinguish whether the gunman was still a present threat. The perpetrator went home, and with that same gun, killed his wife and then himself. Another tragedy for another family. That gun was later stolen from evidence and used again in an interpersonal violence incident, yet another tragedy for another family. That experience is why I'm here today. Like many survivors, I never expected gun violence to become part of my personal story. I expected to be working to support others, not personally wearing a red shirt with the word survivor on it. I'd like to tell you a little bit about my background. As I often share with the survivors I work with in the Everytown Survivor Connect program, the gun violence we've experienced does not define us. It is one piece of our story. My parents made it clear to my siblings and me that we were expected to pursue professional careers, and my path was to go to law school. But I decided to delay for a bit, and I took a job as a counselor in a domestic violence shelter where I volunteered during college. There, I witnessed the courage of so many women attempting to leave dangerous situations. Several women I worked closely with took the brave step to leave their violent partners, but were later shot and killed. The reality is that the most dangerous time for someone in an intimate partner situation is when they leave an abusive partner. It was heartbreaking to share that news with the other residents in the shelter who were carefully planning their own paths to safety. I decided to go to law school to focus on changing the laws related to interpersonal violence. I interned as a victim witness advocate and volunteered at a domestic violence legal clinic where I learned firsthand about the intersection of gun violence and domestic violence. We know that access to a firearm makes it 5 times more likely that a woman will die at the hands of an abuser 5 times. More than 2/3 of intimate partner homicides are committed with a firearm. Eventually, I changed directions and became a licensed clinical social worker. As a mental health clinician, I know that far too often we blame gun violence on mental health issues instead of focusing on access to firearms. Simply having a mental health condition does not mean someone is a threat to themselves or others. House Bill 606 would help keep guns out of the hands of people who have been found by a court to be a danger to themselves or others because of a mental health condition. The perpetrator who shot my parents had a very specific plan in place, one that was known by others, including his therapist. If there had been a procedure in place to prevent his access to a firearm, perhaps my family's story would have had a different outcome. As a mental health clinician in Vermont, I quickly became aware that the vast majority of all gun violence deaths are suicides. In fact, 85% of gun deaths in Vermont are by gun suicide, just 85%. This bill would address a gap in state law by removing firearm access from someone the court deems a danger to themselves or others. I now use my skills in supporting gun violence survivors all across the country. Our backgrounds and our stories are very different. What ties us together is the experience of grieving a mother, a father, a son, a daughter, a sibling, a beloved friend, or having been at the end of a gun in an interpersonal violence incident, or having served in the military and experienced the impact of gun violence, or been part of a mass shooting at a school, a bar, a concert, and the list goes on. I urge you to support House Bill 606 so that other families do not have to live with the lifelong consequences of preventable gun violence. We can do this. Thank you.
Thank you. Any questions? Okay, thanks. Was it Olivia Lee?
Good morning, Chair, Vice Chair, and members of the committee. Thank you for having me here today. My name is Olivia Lee. I am Senior Policy Counsel at Everytown for Gun Safety. I'm testifying in support of H 606. Vermont has made remarkable strides in gun violence prevention over the past several years, and this bill would help the state address one of the remaining foundational policies that it lacks, which is a prohibition on firearm possession for those who have been found by a court to be a danger to themselves or to others by reason of mental illness. This bill would bring Vermont closer into line with federal law in 29 other states. As you heard earlier, federal law bars individuals who have been involuntarily committed to psychiatric facilities from having guns, and this law has been in place for more than 50 years. A separate state prohibition is important to ensure that state authorities can properly enforce this policy. This bill is a step in the right direction. It prohibits people who are subject to court orders for mental health treatment, whether in a hospital or in outpatient facilities, from possessing firearms. And as you heard earlier, under Vermont law, court orders such mental health treatment when a person's capacity to exercise self-control, judgment, or discretion is so lessened that they pose a danger to themselves or others. The key concept here is that this bill requires a court to find, under existing state law procedures that contain due process protections, that a person is a danger to themselves or others by reason of mental illness. This firearm prohibition, therefore, does not apply when someone merely has a mental health diagnosis or when someone is simply voluntarily seeking mental health treatment. It requires a determination of a court under a very specific process that a person is a danger to themselves or others. This principle is a very long-standing principle in both federal and state law restrictions for people who have severe mental illnesses. The Supreme Court in DC versus Heller, which I think someone spoke about earlier, stated that that decision finding an individual right to bear arms was not questioning the long-standing prohibition on the possession of firearms by felons and the mentally ill. And the recent Supreme Court decision in Rahimi from 2024 the Supreme Court specifically evaluated and upheld a prohibition on possession by someone who had been found by a court to be a danger to others. That was in a domestic violence context, but the court wrote at length about how dangerousness was a key factor, and that law enforcement officers needed to watch out for, and it was reasonable to prohibit firearm possession based on those grounds. Additionally, a prohibition like this is still important, even if states have ERPO laws. There are, I think, over 21 states that have ERPO laws and 29 states that have mental health restrictions on firearm possessions. ERPO laws allow a court to order that firearms must be banned, or sorry, must be relinquished by a person if they pose an immediate threat of harm to themselves or others. But those orders are very short, lasting only from 14 days, I think, to 6 months in Vermont. And those ERPOs can be extended under some circumstances. They should exist in conjunction with a more robust and comprehensive system that this bill would provide. And I just want to speak additionally to this for a moment, which is that the state of Vermont already has a process in place to determine that someone needs to get involuntary mental health treatment, whether that's inpatient or outpatient. And we shouldn't be forcing families or law enforcement or medical health professionals to try to initiate a separate process just to make sure that a person who's already been found dangerous by a court can't access firearms for the duration of that order for treatment. So I think that this is going to help families and mental health professionals out in the sense that this mental health prohibitor is going to attach to the order that is already, in the pipeline for getting someone the treatment they need. And you're not going to ask anyone to initiate a separate petition just to make sure that they can't access firearms. With that, I'll end my testimony and thank you so much.
Thank you. Committee, any questions? Okay, thanks again. And next up, we have Greg Lickenbrook.
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to testify today in support of this legislation. My name is Greg Lickenbrock, and I'm Everytown for Gun Safety's Senior Firearms Analyst. Before joining Everytown, I was a gun magazine editor for 10 years. I worked with dozens of gun manufacturers, attended media events and training courses, and tested hundreds of firearms, including machine guns and the firearms designed to mimic machine guns. That's why I'd like to focus my remarks on the machine gun provisions in this bill. So as you've heard, federal law prohibits civilians from possessing machine guns manufactured after May 19th, 1986, as well as the parts used to create them. These parts are known as autosears or machine gun conversion devices, or MCDs, because they convert semi-automatic firearms, which fire one shot per trigger pull, into fully automatic machine guns that will continue firing as long as the shooter depresses the trigger and the gun has ammunition. New technologies, particularly 3D printing, have made it significantly easier for people to manufacture autosears quickly at home. The most common autosears today, devices known as Glock switches because they convert Glock-style pistols into machine guns, can be 3D printed in roughly 30 minutes. A pistol modified with a switch can fire 20 rounds per second. And I've included some photos of all these devices with my testimony. It takes less than 10 minutes to 3D print an autosear that will convert an AR-15 into a machine gun like the kind used by the US military. Like Glock switches, these autosears are routinely sold online as innocuous products. They're called keychains, wall hangers, things like that. Police around the country have seen a surge in autosear recoveries. In January 2024, the ATF announced that it had recovered more than 31,000 autosears in the past 5 years, and Glock switches in particular have been used in over 20 mass shootings. These figures highlight the difficulty of stopping these devices. That's why, to bolster federal law enforcement efforts, 29 states have enacted laws prohibiting machine guns and autosears on the state level, giving state law enforcement agencies the power to go after criminals who obtain these dangerous weapons. In other words, if enacted, this bill will be a crime-fighting tool, a powerful one for the state. But autosears are not the only modifications people seek to enhance their weapons' lethality. As you know, Vermont made the wise decision to prohibit bump stocks and high-capacity magazines in the wake of the Las Vegas mass shooting. in which a gunman fired over 1,000 rounds of ammunition in 10 minutes using 14 AR-15s equipped with bump stocks and high-capacity magazines. That gunman killed 60 concert goers and wounded over 400 others. Since then, gun makers have not only doubled down on AR-15s and other assault weapons, but also other rapid-fire devices designed to get around the federal ban on machine guns. Those devices include trigger cranks, which are manually operated. They pull the gun's trigger each time the crank rotates. There are also bump grips and Hellfire triggers, which operate just like bump stocks. They harness a semi-automatic firearm's recoil energy to keep firing, but they do not use a shoulder stock. So, in other words, they would get around Vermont's current bump stock prohibition. Binary triggers are replacement triggers for semi-automatic firearms, including AR-15s and Glocks, that allow you to fire one shot when you pull the trigger and another shot when you release it. In this way, binary triggers effectively double the host weapon's rate of fire. And then finally, the last example I have are forced reset triggers, or FRTs, which go a step further. Once installed in a semi-automatic firearm, an FRT will automatically return forward after it's pulled. So if a shooter holds the trigger to the rear, the gun will continue firing, which is the very definition of a machine gun. And the federal government had originally cracked down on these devices, but last year the Trump administration reversed course and effectively legalized them again. These are just a few examples of the rapid fire devices that have proliferated in recent years, and I respectfully urge you to consider an amendment that would prohibit rapid fire devices as well as machine guns, as they have no legitimate uses and should have no place in our communities. The original draft of this bill included language prohibiting rapid fire devices, and several states have used similar language in their legislation, which I've included toward the end of my testimony, such as Colorado, Illinois, and Massachusetts. And with that, I will end my testimony. Thank you.
Thank you. Councilmember Wilson.
Yeah, I have a question for you. That was a question I asked someone earlier. In the machine gun ban, there's this ability, it sounds like, to get a gun registered as not a machine gun. And I'm curious about what that process is. Does the ATF come inspect what you have? What is that?
So the ATF has the ability to, if someone sends them a gun, they will rule on whether or not it is a machine gun. They do some testing with it. They see if it fits the federal definition of machine gun, which is mostly carried over for this legislation. So ATF has the power to determine what is and isn't a machine gun.
On sort of an individual basis, but they do actually have to test the weapon.
Generally, yes.
Thank you.
Any other questions? Okay, thank you, Greg. We have on the list for today, Senator Bruce. Yeah, it's been a moment.
I do. So this amendment should look pretty familiar to everyone since we passed it out of the Senate in another version last year. This was part of the work we did on the Burlington Charter, and obviously in that context, it was the municipality of Burlington. There was, as I remember it, grumbling from some quarters about the fact that the Burlington Charter would create a piecemeal structure in which certain restrictions would apply in Burlington and not the rest of the state. So the Burlington Charter, as everybody knows, has been stuck in House government operations and does not look likely to move from there. And so a few months ago, I began considering proposing a statewide version of the Burlington Charter. In other words, a prohibition on guns in bars statewide rather than just within the boundaries of Burlington. And so this is pretty simple in the sense that page 1, line 7A, lay out the prohibition, and the rest of it is really, other than the penalty that follows, all a long series of carve-outs for places where it may not apply, or the people that apply. Wondering, I must have not captured the, Eric, this says page 202, but I don't see an effective date there.
Oh, that's because it's an amendment. It would, the effective date of the underlying bill would apply.
Got it. Okay, so, so with that said, I'll just repeat, my preference had been to allow Burlington to amend its charter. If people don't know, that charter was brought forward originally by an overwhelming vote of the voters 12 years ago. It was allowed to die in the House. At the time, I and others opposed that, but that's what happened. Then if you go back a couple of years, we had a particularly shocking murder outside of Red Square in Burlington. And voters went back to the polls and renewed the vote on the charter by an even more overwhelming margin. So this comes with an urgency from Burlington, but I think the principle applies statewide, and it's simply said, which is that in a place where people are in the process of becoming intoxicated, we do not want firearms available to them in that context. So with that said, Mr. Chair, this is placed on the table. I'm happy to help provide people for the witness list. And that's about it.
Would it apply to hotels that have bars?
It has a carve out. It says that it does not apply to second class licensed premises, including the premises used for retail alcohol beverage tasting permits. That's lines 12 and 13. So that's the distinction that's in play. And then down below, the sidewalks are public highways through which people are passing, and a dining car that holds a promotional railroad ticketing permit not included.
In terms of the liquor license classes, I worked pretty closely with Tucker on navigating for the Burlington Charter, which liquor license classes were excluded, and which it's been over a year since I did that, so I don't remember what all of them are, but all of this is to say Tucker would be a great witness to come in and explain the differences between the classes of liquor licenses, but I do believe it would include hotel or bar.
I think Eric has something.
Yeah, and just to reiterate, Senator Wachowski's point as well, those exceptions are identical to the exceptions that were in 131 as it passed the Senate, as it would apply to a hotel, the way, and Tucker would be a great person if I had to, as you might expect, talk to him at length this week, so that I could also not as well as him, but we understand what's going on with the licensee issues here. Generally speaking, the way a license works, for example, in a hotel bar, which there are plenty, the first class license applies to the sales of beer and wine, third class license applies to sales of spirits for consumption on premises. And the premises is licensed for serving and consuming those types of alcohol is very specifically set out in the license in terms of the geography, specific portions of the area, for example, a hotel bar, where you can consume the drink that you bought there. So yes, if the firearm is possessed in those premises that have been defined in their license very specifically as to where it goes on the ground, then that would be covered. In other words, yes, that would be prohibited in those premises. It would not be prohibited in the other portions of the hotel where the consumption of alcohol under the license applies. So if you think of a hotel bar, that's the area of the premises where the alcohol is consumed. Outside of that, it's not physically roped off, but you sort of imagine it's roped off on a map on their license.
Right, I'm not allowed, for example, to sell and consume at the reception desk.
Exactly.
So if you have room service, you're not, if you can get a drink in a room in a hotel, you're not allowed to travel with a firearm?
That's an interesting question because I'm not sure how the licensing interacts with the fact that, say, you can take a drink up to your hotel, up to your road. So that would be a good follow-up question for Tucker as to, because you're probably not in the licensed premises, but you are consuming the drinks that you buy there.
I wonder if that's fairly similar, because I believe we have permanently codified the ability to order mixed beverages from restaurants to go.
Right.
And so it is delivered to me at my home. I'm not in the licensed establishment.
Yeah, that's a good point, because the phrasing of the prohibition is in the premises where the alcohol is licensed to be served. So if you're not within that premises that's cordoned off, at least metaphorically, in the license, then it wouldn't seem to apply because you're drinking it in your room, not in the premises.
I was curious about that Burlington one. Trying to remember exactly what happened. Was the person involved in the shooting were they in the bar?
Yeah,
And then they went out of the bar?
they were in and out, and the last time that they went out, the woman shot the mansion and having an altercation.
Was she under the influence?
I would think they both were, because they had been in there for a few hours. So I don't know if she was legally over the limit, but they had been consuming alcohol as well.
Is that anywhere in here about being over the limit or just?
No. It's just a sensitive locations, prohibition.
Because it's not a prohibition on someone who has consumed alcohol from being in possession of a firearm. It's
Right.
prohibition on having a firearm in a premise.
In that place.
Yes.
Yeah. Yeah, so it doesn't matter if that any.
Yeah. So, I was just gonna say, it's just the sidewalks, public highways, so I'm thinking Church Street, they have the seats out front.
And
You
this was
sit out there with them.
Senator Wahowski's addition to this. So if you're passing, like if you imagine Church Street and you've got tables and the sidewalk goes through, you're fine having a firearm as you pass through. But if you take a seat at one of their tables, you're in their premises. Is that?
Yes.
Yeah.
Yes, and those are, as Eric was explaining, those outdoor serving areas are cordoned and defined by the license. And in many of them, they are actually roped off.
Yeah.
And when it comes to licenses, it's the licensee, I'm looking at page 2, line 13, to the bar owner can carry a firearm, but none of the bar staff.
Right. And I think that was a concession to the idea that it may be their property. And so it preserves their Second Amendment right on their own property.
Any other comments or questions on this one?
Fairly familiar with this language.
Right. Anything else generally on 606 before we wrap up for today? No. All right. Sounds good. Well, we've got some other testimony for tomorrow and then we'll just keep working through it.